filed on count 11, there's no bond, which is a two-way communication device. So I was just going to. That's the only reason I left them.
Okay.
Likely.
Just gonna put these here, AJ. You gander right there.
I called the hospital this morning.
Okay. Old engine they could.
Yeah, that secret hospital list. People on probation.
Oh, are you talking about? Yeah, I don't know. Just like this is David's case. What? Yeah.
Sounds good. Thank you. Miss Ray?
Good morning, sir.
Good morning, ma'am. Come on.
You ready for me?
Yes, ma'am.
Warrior Ray on behalf of Pablo Ruiz. He's incarcerated. May we approach whenever he gets out?
Yes, ma'am. Yes, ma'am. State.
Friday from 10 a.m. till 4 p.m. and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Days Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service.
How you doing, sir?
Good, how are you?
Good.
Mr. Ruiz, so you're here on the motion to set bond. It's my understanding that the state and the defense have agreed to a $75,000 cash or professional bond on count 1, $1,000 signature bond on counts 2 and 3. So if you post that, they'll let you out of jail. Stay in touch with your attorney. Will I see Mr. Ruiz on May 13th?
We're asking for continuance, Judge.
Ma'am?
Asking for a continuance, Your Honor.
Okay, so until July 8th?
Yes, Your Honor.
Yes, sir.
Mr. Ruiz, I'll see you on July 8th at 9 o'clock.
Okay, thank you.
Thank you, sir.
Thank you, sir. Have a good morning.
Thank you, ma'am. You too. Mr. Ufelter. Ufferman. Oh, Mr. Ufferman. Sorry, my glasses aren't working.
Hello, Your Honor. Good morning.
There.
Michael Ufferman.
Good morning, sir. Let's see, Mr. Ufferman. Stoffel?
Oh my God.
Okay, the bailiff just...
Your Honor,
Yes, sir.
I'm here on Mr. Stoffel's case. It's case number 2014 CF 1876. The case is before the court on a Rule 325 motion. However, I know I've mentioned this in previous status conferences that we've had. I've been working with Ms. Basso, who's a pleasure to work with, and we are engaged in possible resolution discussions. In fact, we're in the process of scheduling an in-person meeting so I can go over and meet with, sit down with her and perhaps the other people in the state attorney's office to see if we can possibly get a case resolved. That meeting should be taking place in the next 2 or 3 weeks. And either we'll have a resolution to potentially present to Your Honor, or we won't, and it'll be time to reset it for an evidentiary hearing. Obviously, I'm hoping for a resolution, but that's where we are. I would ask that this be set off perhaps for another 45 days or so, and by then we should have an answer as to whether or not we're going to be able to present a resolution to Your Honor, or whether we need to proceed with the hearing.
Okay, and Mr. Ufferman, do you waive your client's attendance here? He refused to come down from the jail.
I definitely waive his attendance. There's no reason for him to be here today. This is just a scheduling matter, Your Honor.
Okay, what happened on the state's request to take judicial notice? Is that still pending?
Your Honor, I don't think there's a dispute about the state's request. If we end up proceeding to a hearing, I'm not going to object to their request.
Okay. So just because I keep carrying that around, wondering if I'm going to rule on it at some point. So.
No, I wasn't aware of that, Your Honor. I didn't know that's what was causing this to stay on the calendar. I don't think that's an issue that we need you to decide right now. That's,
okay.
Again, if we proceed to a hearing next, I'm not going to be objecting to the state's request. I agree that what they're requesting the court to take judicial notice of is in fact relevant to the case.
Okay. So, Mr. Ufferman, do you want to continue it until June 10th?
That'd be great, Your Honor.
Okay. So June 10th at 9 o'clock.
Perfect.
And,
Yes, ma'am. Please.
Judge, may I approach?
Yes, ma'am. Can you approach? Then we won't be able to hear you.
I do know that Ms. Paulson has a conflict on June 10th. I think you should take it on a miscellaneous day.
Okay. Yes, ma'am. The next date I have is June 13th. Will that work?
Yes, Judge.
Okay. Mr. Ufferman, June 13th at 9?
Yes, Your Honor, that works.
Okay. And when I'm saying 9, that means it's not going to be an evidentiary hearing. Is that what you want, or do you want it in the afternoon where there's more time to take evidence?
No, so I would ask that we set this for another status conference.
Okay.
And at that status conference, I can inform you whether we have a resolution to present to the court or whether we need to pick a date. If we need to pick a date, we can do that at the next, on the June 13th hearing.
Okay. So June 13th, 9 o'clock for a status.
Perfect.
Good.
Thank you, Your Honor.
Thank you, sir.
Good seeing you. Have a good day.
Thank you. You too. Yes, ma'am.
Good
Morning,
Your
ma'am.
Honor.
Madam Clerk.
Your Honor, this is Mr. Manuel Mahia Garcia. He's on the 130 docket.
Yes, sir. Yeah, hold on 1 second.
Yes, sir.
Do you swear or affirm that you'll make an accurate, complete, and impartial interpretation from the Spanish language into the English language and vice versa relative to the cause now under consideration before the court?
I do.
Your Honor, he is on the arraignment docket. I met with Mr. Mahia Garcia yesterday. I only left him on today's docket because when I was reviewing the paperwork, when he went through first appearance, there were 10 bonds set at $25,000 cash or professional. However, count 11 was not addressed at first appearance. I don't think it existed at the time. So I only left him on today. Number one, I'll waive the formal reading, acknowledge the receipt of an 11 count information, enter a not guilty plea. However, on count 11, we would request that the court set an ROR bond on that particular count.
Okay. To the state on count 11?
Judge, we have no objection to an ROR bound on count 11.
Okay. Mr. Mahia Garcia, your bond set and released on your own recognizance on just count 11.
And Your Honor, Mr. Mahia Garcia is currently scheduled for the May 13th docket. This case is not going to be ready for disposition on that date. I would ask the court for continuance, and I did discuss this with Mr. Mahia Garcia yesterday. Oh, just a 1 second.
Mr. Mahia Garcia, do you agree to continuing your case from May 13th to July 8th?
Yes, sir.
Thank you, sir. I'll see you no later than July 8th.
I'll come see you. Okay. You can have this if you want, but I would advise you to let me keep it. I mean, it's up to you. Okay, sorry.
Can I give my wife your phone number?
Can I talk to the attorney real quick? Okay. I'll wait.
Okay, thank you.
That's not him. It's Phelps. Or Paulson, sorry.
Rico Trujillo, pase por favor. Pase por aquí y habla aquí.
Okay. Your Honor, just for efficiency's sake, the state is in receipt of a drop charge request by the victim. We have not actually been able to speak with the victim in that case, so we're not willing to dismiss it yet. However, given the drop charge request, we are stipulating to a reduction of these bonds to signature bonds.
Anything else, Mr. Couch?
Good morning, Judge.
Good morning, sir.
If I may just briefly take advantage of the Spanish interpreter.
Yes, sir.
The state has agreed to allow you to sign out, so you'll be able to sign out of jail. You do still have an ICE hold, but you'll sign out on this charge and see if there's any transportation or they're going to release you. Stay in contact with me. Here's my card. And our next court date's going to be here, May 13th at 9 a.m.
Tienes que estar aquí ese día. 13 de mayo. 13 de mayo te lo escribí aquí. Mayo 13 a las 9. ¿Ok?
The signature bond is for $20,000. So what that means is you'll be able to sign yourself out of jail today. But if you fail to appear when you're supposed to be here, then you'll owe $20,000. And I'll see you on May 13th at 9 o'clock.
Thank you, Judge.
Thank you, sir.
Stamps don't expire today.
Number 6, Parker, Stewart. His attorney needs to.
I don't know. I don't want to answer that. I'm nervous. I don't know.
That's all I have this morning, Your Honor.
Thank you, Tracy. Good seeing you. Mr. Karpinski is next on Mr. Saxton's case.
Good morning, Your Honor.
Good morning. Good morning, sir. Yes, sir.
Judge, I'm here in my conference room. My client is sitting across the table from me, Mr. Saxton.
Okay, so
Judge, this is a VOP, and there are two allegations of the VOP. One of them is that he was went outside of the allegation was that he went outside of the area he was supposed to go to. And what I have received from my client this morning that I want to share with the prosecutor, I'll email it to her when we're done here, is some documentation that he was at a doctor's office in Jacksonville. My client is suffering from terminal leukemia. He has a host of other medical issues. He's undergoing chemotherapy and dialysis and all kinds of things. So I just want the opportunity to present this to the prosecutor and see if we can't resolve it that way. I understand when we were here last time, you said that if we didn't have it resolved today, we would set it for evidentiary hearing, and we're fine with doing that. If we can do that in about 4 weeks.
Okay, to the state, any objection to setting it with subpoenas in about a month?
No objection, Judge.
Okay. So let's set it for May 23rd at 2:30.
All right.
Okay.
And I will, Ms. Bergman, I will email, you'll get an email from me later today with the latest information I've got.
Thank you.
Thank you, sir.
Thank you.
Yes, sir.
Thank you, Your Honor. Have a good day.
You too. Okay, I don't see any other private counsel. Let's see if we have any pro se's. I don't see any. Okay. Mr. McKinney?
Judge, I have Mr. Walters in the audience.
Good, thank you.
Mr. Walters traveled from Texas to be here today to enter the plea. He is present in 23 CF 1976. Mr. Walters is going to be entering a plea as charged. This is a constructive possession case. He will be adjudicated guilty. He's previously been adjudicated. He will be placed on 2 years of probation. No objection. We're asking for no objection for a transfer of supervision to Texas. He's already talked to probation in the courtroom today. He has the $100 to initiate the paperwork to transfer to Texas. Special conditions of the probation would include forfeiture of the firearm involved in this matter, $515 in court cost, $150 cost of defense. There would be a standard cost of supervision. I've explained to Mr. Walters that if his supervision is transferred to Texas, they may have different numbers than we do, that you have to abide by what Texas says.
Good.
May I approach?
Yes, sir. Mr. Walters, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Mr. Walters, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Very.
Did you sign the plea agreement?
Yes, sir.
Mr. Walters, I do accept your plea. You're adjudicated guilty. You're sentenced to 2 years probation. The subject, firearm, I think that's what it is. Yes, the subject firearm is forfeited. You'll need to pay the court costs, $150 public defender's fee. You will need to pay the $40 per month cost of supervision, but that may vary because the court has no objection to you transferring your supervision to Texas.
Yes, sir.
Yes, sir, Mr. McKinney?
Judge, no objection to the score sheet, but reflects 28.5 points. May I approach with that?
Yes, sir. Thank you. So, Mr. Walters, get the okay from probation here before you leave, okay?
Yes, sir.
Thank you, sir. Good luck to you.
Okay, good to go. We're going to go to the room on the way out, or we're going to tell you to go to 13 Kelly.
Thank you, Judge.
Mr. Walters, you'll have right of you.
Oh, yeah, they're going to need fingerprints first.
Joshua Paulson is next, Judge. What's your copy?
Thank you.
Morning, Josh.
How you doing?
Good.
Yes,
Honor,
sir.
can I just have a brief moment?
Certainly.
If you can.
bond hearing?
He has one on Miss Yepez on amphetamine trafficking.
Thank you, Judge.
Yes, sir.
Good morning. This is
Do you
Mr.
have
Joshua
more than one?
Paulson. We're hearing case number 2024 CF 562. And Your Honor, we'll also be addressing case number 2023 MM 4053. And to all charges and counts, it's going to be adjudication of guilt, 90 days in Okaloosa County Jail with credit for time served. There's 967 in court costs in the felony case and 270 in court costs in the misdemeanor case. There's $250 for defense costs. We also added a letter of apology to Officer Montgomery. My client did initial by it at the plea form. And I advise my client, he can write the letter, I can get it to him at the jail, and I can provide it to the state attorney. May I approach with the plea form and the score sheet, Your Honor?
Yes, sir.
And this will be adjudication of guilt.
Yes, sir. Thank you, sir. So as far as the letter of apology, he's going to have to do that within what period of time?
I think it's reasonable that he can write it while he's in jail and give it to Mr. Koch, so that way, by the time he gets out of jail, he's done. There's no more responsibilities for this case.
Okay, so the letter will be done before he's released from the Okaloosa County Jail.
Correct, Your Honor.
And to make it easy, Judge, I can, my client can write that letter tonight and tomorrow, and I can go to the jail tomorrow to receive that letter. I can send a copy over to the state.
Okay.
Just to make sure it's completed.
Mr. Paulson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Paulson, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Paulson, I do accept your plea. You're adjudicated guilty. You're sentenced to 90 days in the Okaloosa County Jail. That's with credit for all time served, and that's to run concurrently between each count and each case. You'll need to pay the court costs in both of the cases, total of $250 public defender's fee. You will need to write a letter of apology to the officer before you leave the jail.
Okay.
Thank you, sir.
Can I ask you a question?
Right this way, Mr. Phelps.
Thank you.
Yes. Judge, if I just may have a brief moment.
Yes, sir.
Thanks, Judge.
Yes, sir.
Judge, this is Mr. Jonathan Phelps in case number 2024 CF 143. Your Honor, my client will be admitted to the violation. It's revoke and terminate probation, 90 days in the Okaloosa County Jail, and will receive credit for time served, $100 for the cost of prosecution, $150 for defense costs. If I may approach the plea form.
Yes, sir. Mr. Phelps, if you'll please raise your right hand.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You can put your hand down.
Yes, sir.
Did you read the plea agreement?
Yes, sir, I did.
Do you understand it?
Yes, sir, I do.
Did you discuss it with your attorney?
Yes, sir, I have.
Did he answer all of your questions?
Yes, sir, thoroughly.
Are you satisfied with his representation?
Yes, sir, I am.
Did you sign the plea agreement?
Yes, sir, I have.
I do accept your plea. You're adjudicated guilty. Your prior supervision is revoked and terminated. You're sentenced to 90 days in the Okaloosa County Jail with credit for all time served, and that's to run concurrently, run at the same time between each count. You will need to pay the $100 cost of prosecution, $150 public defender's fee. Mr. Koch, how long will your client need to pay that and any other financials he had?
Your Honor, we can get 6 months.
No, no, sir, I'll have that paid in 30 days.
Okay. Then how about I'll give you
Thank you, though.
Okay.
Thank you.
okay? So if you fail to pay it within 30 days, then it will go to a civil lien or judgment.
Yes, sir, I understand.
Thank you, sir. Good luck to you.
Yes, thank you so much.
Hey, best of luck, all right?
Thank you.
Yes, sir. Her last name is Ruiz. Oh, I'm sorry. If I could have a moment, I'm sorry.
Tammy Leighton's gonna be next with Mr. Hines.
Thank you.
She's not gonna be on the roster.
Okay. Thank you.
Your Honor, this is Miss Tammy Leighton in 23 CF 1367. We have reached an agreement to resolve Miss Leighton's case. Oh, I'm going to write on the plea form that the state's going to take no action on the failure to appear. Okay? Miss Leighton is going to be entering a no contest plea as charged. The agreed upon disposition is that Miss Leighton will be placed on 2 years of probation. She'll be assessed $610 in court costs, $150 in public defender fees. She will perform 24 hours of community service as a condition of probation. She will also submit to a substance abuse evaluation and any recommended follow-up treatment. The state will take no action on any failure to appear in this case, and there will be a withhold of adjudication.
And she has to pay the cost of supervision.
$40 a month cost of supervision, yes, sir.
Good.
May I
Thank you.
approach?
Yes, sir. Ms. Leighton, if you'll raise your right hand. Do you swear, God bless you.
Thank you.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Leighton, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
He did, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Ms. Leighton, I do accept your plea. Adjudication is withheld. You're sentenced to 2 years probation. You'll need to pay the court costs, $150 public defender's fee, $40 per month cost of supervision, perform 24 hours of community service work, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. Good luck to you, Ms. Leighton. Thank you, ma'am.
Thank you.
I'm sorry, who?
James Adams.
Thank you. Hello, Mr. Adams. Good morning, sir.
Your Honor, this is Mr. Adams. We are still in the process of speaking over, all of this is based out of Pensacola. So he was being supervised out of Pensacola. He was in the REAP program in Pensacola. We are still gathering information from Pensacola, from the probation officer, trying to track down some body cameras from this incident that's mentioned in the VOP report. We are going to ask the court for a continuance to the May 16th date without subpoenas.
Okay. Mr. Adams, do you agree to that continuance?
Yes, sir.
I'll see you back here no later than May 16th.
Just so the court's aware, and I'll talk to the jail, Mr. Adams is in the 6-month registration window right now, and he was just informing me that he's tried to register at the jail, and the jail is informing he cannot register. I just want everyone to be aware that he is attempting to comply with the registration requirements. So I will talk to the jail, see if we can make a registration happen this month.
Good. Thank you, sir.
Yeah, technically it is.
Next is James Lawrence.
Thank you. Hello, Mr. Lawrence.
Under probation. Not doing anything other than what he said.
So modify.
Your Honor, this is Mr. James Lawrence. We are awaiting an evaluation from Keaton. Unfortunately, I just have to ask for a continuance to the May. I'll ask for the May 13th date. I know that's the pretrial, but frankly, I'll be honest. If we get word that he's accepted, I'm going to ask the court to come on down to a courtroom if you can. At any point, I'd like to get him off to Keaton as quick as possible.
Okay. What I'll do, Mr. Lawrence, that day we've got probably about 300 people somewhere between 200 and 300 people that'll be here that day. What I'll do is schedule you for May 23rd at 9 o'clock. But, Mr. Kleins, if he's accepted at Keaton and the state agrees to that, then I'm authorizing you to put him on the docket for the 13th. And I'm sorry, I said the 23rd, that's wrong. Let's do May 16th.
Okay.
At 9 o'clock. But if he's accepted into Keaton and the state agrees, then you're authorized to put him on the docket for May 13th.
Thank you, sir.
All right. Thank you, sir.
Next is Jerry Mays.
Thank you.
For Mays. You want me to pass them to the end of the docket so you can read it? It's kind of.
Hello, Mr. Mays. Good, how are you?
Yeah.
Your Honor, Mr. Mays is on today's docket for a motion to reinstate bond. If we could pass Mr. Mays at the end of the docket, I'm still talking to Mr. Gomez about whether or not the state may stipulate to this.
Okay.
So
I'll see you later this
yeah,
morning.
you can come back out.
JJ, Mr. Mays is gonna have to come back.
Shaquille Moon is next.
Thank you.
Your Honor, this is Mr. Moon.
Oh, Mr. Moon.
Hello, good morning.
Good morning.
He is here on a motion to reduce bond. There is a potential fact in the motion that I think it may be incorrect, so I just need to take some brief testimony from Mr. Moon.
Okay, Mr. Moon, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down.
Mr. Moon, if you were released on bond, where are you going to be living?
1654 Percy Coleman Road, Fort Walton Beach, Florida.
And who lives there?
It's like a shelter.
It's a shelter, okay. Sir. Now, did you used to live at 824 Southern Court?
Yes, sir.
And why do you not live there now?
I've been incarcerated since Thanksgiving Day, so they had to unfortunately evict me.
Okay, and if you're released from custody, what are you going to do for a living?
I currently still have my position open at Panda Express.
Okay. Have you ever failed to appear for a court date?
I have never failed.
Okay, I have no further questions.
Any questions from the state?
No, Your Honor.
Mr. Klein's argument?
Yes, sir. So, Your Honor, we are asking the court to reduce the bonds in these two cases. Mr. Moon has a third case that is represented by Ms. Jaquit. That bond in that case is not subject to this motion. We are asking the court to reduce a $10,000 cash professional bond in 23 CF 2625 to a signature bond. And we are asking that the court reduce the $2,000 cash professional bond in 24 CF 536 to a signature bond. Mr. Moon has been incarcerated since last November. We have been making efforts to try to get Mr. Moon into the vet court program. I don't recall ever being told that a program in the area doesn't have the services to help somebody, but that's what we have been informed from vet court, is that they don't think they have the services. Doesn't make a lot of sense to me. There's clearly anger management issues in these cases. I did meet with Mr. Moon yesterday, and I'm going to talk to the state about potentially seeing if mental health court might be an option for Mr. Moon. And even if the court grants this motion, and he is aware of this, that does not affect the bond in 23 CF 773. That's a $17,000 cash or professional bond. It has not been revoked, but his bondsman surrendered Mr. Moon's bond in December of last year. So even if the court granted this motion, he would not be released unless he reposted $1,700 with another bondsman. So we are trying to get these cases resolved. He is simply asking the court to consider reducing the bonds in this particular case. Mr. Moon would be living in the area. He continues to work at Panda Express. He is looking at a presumptive DOC sentence in these cases. I think 36 points of that would be for Ms. Jaquit's case. So there is a presumptive DOC sentence, at least as of right now, but we are asking the court just to consider reducing the cash professional bonds to signature bonds in this case, in these two cases, I should say.
To the state?
Yes, Your Honor, I think at this time, the state would respectfully request that the bonds remained in place. When we're looking at the case in 23 CF, sorry, make sure I say the right case number. For example, in 23 CF 773, the allegations are that he forced his way into his grandmother's home, battered her, and then as she's trying to call 911, he interfered with the 911 call. Post Miranda, he admits that he became frazzled, he may have pushed the door open hard, and that he did interfere with the 911 call. Then, while he's incarcerated, he then has this new 24 case, which is yet again another example of a display of violence. And so there is a concern that this defendant cannot control his temper, and that if released, he would commit a similar violent act on somebody that is out in the community. And so for those reasons, namely the fact that while he was incarcerated, he commits another new law offense, further indicating or displaying to this court that he can't necessarily follow the law with respect to his temper, we would respectfully request that these bonds remain in place, Your Honor.
Thank you. Mr. Klein's fine.
I think Mr. Gomez accurately recounted the allegations, which in a roundabout way kind of bolster our argument that he needs some support here, he needs some help. That's why we've been trying to get him into vet court. Just yesterday is the first time mental health court got mentioned by Mr. Moon, so I will talk with the state about that. But I tend to agree that there's some anger issues probably with Mr. Moon, and be that as it may, he is requesting the court to consider reducing these as I previously stated. Even if the court reduces these, I don't even know if he can afford the bond in the other case.
So to the state, when was the alleged incident in the 773 case?
Hold on, Your Honor. I just had it pulled up. April 4th of 2023, Your Honor.
Okay, because Mr. Moon, as I was doing my homework, I looked and I read the sworn statements for the alleged battery while you were in the jail, intentionally struck Tommy in the face with his head, and that they allege that they've got video surveillance of that. And then also on November 23rd of last year, that's why I was asking about the 773 case. So the alleged incident in April of 23, and then in November of 23, the allegation is that struck Shaquille in the left eye, left rib cage area, his mouth, causing his dentures to break in half. And then they talk about photos and the observation of the officer. So respectfully, your motion to reduce bond, I have concerns about the safety of the community. So respectfully, it's denied, but I hope the mental health court will take you in.
Oh, thank you.
Okay. When will I see Mr. Moon next?
Mr. Moon is on the May 13th docket. We could leave him on that docket. Hopefully, I hope we can get this resolved.
Okay.
Yes, sir.
Thank you, sir.
I'll come talk to you before then, okay?
Yes, sir.
Okay, good, thank you.
Judge, if we call Mr. Daniel Peterson, who's present, approaching.
Hello, Mr. Peterson.
Sir.
Good morning.
Good morning. We're here in case number 23 CF 731. The basis of the violation was a new law, and that new law is 24 CF 681. That case has been no process. So the state has no objection to dismissing and reinstating my client back on probation, sir.
That's correct, Your Honor. Because the nature of the violation was dismissed, we will be willing to dismiss and reinstate the defendant to complete his original terms of supervision.
Okay. Mr. Peterson, the violation of probation is dismissed, and you have your supervision that you were on before this incident?
Yes, sir.
Is reinstated, okay?
Thank you, sir.
Thank you, sir.
And Your Honor, I have Ms. Joanne Rudd, who's present here approaching. And this is case number 23 CF 1987. Your Honor, if I should have a moment just for
there's no order appointing yet.
That's me. Thank you.
Today's the 18th.
Thomas Red.
Thank you, Your Honor.
Yes, sir.
Your Honor, this will be, our client will be admitting to the violation. This will be a reinstatement. Her probation will be modified. We'll be converting it to the drug offender probation, which has the curfew from 7 p.m. to 7 a.m. We will also be adding a substance abuse evaluation with any recommended treatment. And there's $100 cost of prosecution and $150 for the cost of defense. My client was adjudicated on the original plea. I'm just going to hand this to the state attorney just for a signature, Your Honor.
Yes, sir. Ms. Rudd, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Thank you, ma'am. Ms. Rudd, did you read the plea agreement?
Yes, I did.
Do you understand it? Is that a yes?
Yes, sir.
Okay. Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
I did.
Ms. Rudd, Mr. Koch has explained to you what drug offender probation entails?
He did.
Okay. Ms. Rudd, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated and modified so that the balance of your supervision is drug offender probation. You'll have a 7 p.m. to 7 a.m. curfew. You will need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. You'll need to pay the $100 cost of prosecution, the $150 public defender's fee. Ms. Rudd, I wish you the best, ma'am.
Thank
Are
you,
the
sir.
original terms reinstated?
Yes, ma'am, all the original terms are reinstated.
Okay. Yep. Thank you, Judge.
Yes, sir. Okay, thank you.
Judge, Katie Jaquette had emailed me yesterday and said she was filing a motion on this case as well, and I was appointed to a misdemeanor case, and so I just showed up today in order, if I've got a proposed order to appoint me to this case.
Yes, sir. Good, thank you. Thank you.
What is the state's offer on the bill? Anybody know?
I'm sorry, who is this?
Yeah, Parker, sure.
Hold on, Your Honor, I'm trying to find this person on the docket.
23 CF 2328.
He was added when?
No, it's under Ms. Jaquet's name.
Oh.
It's number 7 on my doc. Morning, sir.
As of right now, the current offer is to modify probation to community control for the next 12 months.
Judge, let me go, if I could just have a moment, I'll chat with him.
Sure.
And then mention one more thing to state.
Okay. Mr. Stewart, I'll see you later this morning. Thank you.
No, I'm not going to make that call. Yeah.
What about trying to resolve
Thank you.
this?
Hello, Mr. McKinney.
Good morning, Judge.
Good morning, sir.
That's what's violated.
Hello, Ms. Watson. Good morning.
I'm sorry, who is this judge?
Mia Watson.
Okay.
This is a volunteer.
Ms. Watson, I read through the motion, and some of the things it says is that you've been in jails since February 24th of this year, that your present bail is $2,000.
Your Honor, I'm sorry. For the sake of efficiency, the state is going to stipulate to reducing this cash professional bond to a signature bond.
Okay.
Sorry about that.
No, not a bit.
Judge, it's a $1,000 cash professional in each of the two counts, which means, I guess we would be asking the court to convert that, each of those to a signature bond.
Ms. Watson's mother filed something with the
Yes, Your
the
Honor.
clerk, and in there she said, Mia needs help. She's an alcoholic, has low blood, and mental issues. Then I think that I saw, in the first appearance paperwork, it said no criminal history. See if this was the one. I don't think it was.
The score sheet reflects 4.7 points for Ms. Watson. So
Yes, sir.
I believe there might be a misdemeanor out there, but very little criminal history, if at all.
And it wasn't this case. There must be another one that there was other alleged evidence of some mental health, and that's what I was looking at, but I don't see that in this case. So, Ms. Watson, your two $1,000 signature cash or professional bonds are converted to signature bonds, so you'll be able to sign out of jail today without putting any money up. If you fail to show up in court when you're supposed to, then you'll owe $2,000, okay?
Okay.
Mr. McKinney, am I going to see Ms. Watson on May 13th?
Yes, Judge, she will be back on May 13th at 9 a.m. for pretrial. We do have depositions scheduled for May 8th, so we should be complete with all of the discovery we need to do by the time we get to May 13th.
Good. So I'll see you back here May 13th at 9 o'clock. Stay in touch with Mr. McKinney, okay?
Okay, thank you.
ma'am.
Misty, what else?
Thank you.
Okay.
Williams, I think so, yeah.
Call that number,
Okay.
and then schedule an appointment. It's at that address.
That's the misdemeanor.
Okay, you're good.
Okay, thank you.
Thank you, ma'am.
This case, this misdemeanor case is not set to May 15th, just have plea down. So it's got your offers to convert from control for the balance of probation.
Yeah.
Judge, this is Ms. Woodhams before the court. She is here in two case numbers, 23 CF 2355 and 23 CF 2382. Each of those are felony violations of probation. At the last court appearance, I was appointed to 24 CF 605, which is a new law case. I believe that Mr. Snell was intending to file the information in that case, and I believe that everything was going to end up on May 13th. Madam Clerk, has an information been filed at this time? 24 CF 605.
Good morning.
Good morning. No.
Judge, if we could schedule everything for May 13th, I will reach out to Mr. Snell. I know I discussed this with him again this morning. I believe it's the state's intention to file the charges in 24 CF 605, but I'll discuss that matter with him prior to us coming back to court on May 13th.
So, Ms. Woodhams, I'll see you on all three of your cases on May 13th. Okay. Thank you, ma'am.
Thank you.
As soon as I
Can I go Frier?
Thank you.
Okay, anytime. Okay.
Hello, Mr. Fryer.
Judge, this is Mr. Nigel Frier before the court in two case numbers, 20 CF 2443 and 21 CF 192. Each of these are felony violations of probation. We had passed it over today from his arraignment to identify if there was going to be an offer from the state. I'm unaware if there's an offer from the state at this point. Originally, Mr. Frier was sentenced as a youthful offender. to 1129, followed by 2 years of probation. He does score, at least on that score sheet that Judge Stone signed, it was approximately 68.5 months, but he was sentenced as a youthful offender, meaning that the score sheet really doesn't apply. So the court would have to go by the youthful offender sentence if we were to admit the violation of probation to Your Honor, and if we were to enter any negotiated agreement with the state.
To the state, do you have an offer for Mr. Frier?
It's going to be an incarceration offer, Your Honor.
What is it? What's the offer?
This isn't my case, Your Honor. I'm not, it's going to be probably somewhere around the neighborhood of 3 years to 4 years.
Which is within the youthful offender.
That would be within the youthful offender, yes, Your Honor.
And Mr. Frier has been incarcerated about 15 months, given between Alabama, I believe Georgia, and here. So there are some moving pieces to this. I would ask for a continuance and ask for one more court appearance to be set without subpoenas. If we're unable to resolve it on that court appearance, then we would be setting this for an evidentiary hearing.
Okay, so do you want it, on May 16th, May 23rd?
Judge, if we could have May 16th, because it's the next available, because I know that Mr. Frier does want to have this matter resolved.
Y'all already been incarcerated 50 days?
Yeah. So we need to figure out if we're going to a plea to the bench or if we're able to negotiate something with the state other than 3 years Department of Corrections.
Okay. Mr. Frier, I'll see you no later than May 16th. Thank you, sir.
As soon as I get an answer, I'll come talk to you.
Yes, sir.
Judge, this is Mr. Timothy Frymeer before the court in 20 CF 1932. First off, definitely thanks to the court for signing the motion in order to transport him to resolve this matter, which is a violation of probation. He has got about 4 to 5 months to go on his other sentence, and we're trying to resolve this matter to hopefully get him into a program in Tallahassee upon his release. I need to enter a denial today now that the violation of probation has been served on Mr. Frier, so I can discuss with Mr. Snell the treatment program over in Tallahassee, what that entails, to determine if we're able to revoke and terminate this supervision or what we intend to do with it. So we'll just enter a denial and ask for a court date to be set without subpoenas on May 16th.
Okay. So, Mr. Frymeyer, I'll see you no later than May 16th, okay?
Yes, sir.
Thank you, sir.
So I get an answer.
Hey, Jason.
I'll let you know.
I'm sorry. On Friday.
Samuel
The
Stevens.
one before, is that set for 516?
Thank you.
Yes.
Okay.
All set for 516, no subs.
Gotcha.
Okay, sure. Is that anything else? Okay. Judge, this is Mr. Samuel Stevens of the second before the court. This is 12 CF 2430. This is a felony violation of probation. I did file a motion for the court to appoint an expert for competency because Mr. Stevens had not met with Dr. Zeman. I discussed this with Mr. Stevens on Tuesday. I discussed the importance of complying with the evaluation. I believe that his intention at this point is to comply with that, but we would need to have that evaluation in hand before we can realistically move forward with his felony violation of probation. So I would request the 5/16 court date for status.
Okay. Mr. Stevens, as I was doing my homework, I saw that a month ago we were here, and in the minutes it said that Mr. McKinney was going to seek the evaluation. I also see that not until 2 days ago did Mr. McKinney file the motion seeking that. And that same day, on the 16th, I signed that order. Mr. McKinney, why did it take you a month to get me a motion?
Judge, we sought a confidential evaluation with Dr. Zeman so that I can also include mitigation and factors relating to the violation of probation to potentially have Dr. Zeman testify in the courtroom for the violation of probation. That's done in-house because it's a confidential evaluation without a court order. That process was done immediately, and Dr. Zeman went and traveled and met with Mr. Stevens. Mr. Stevens refused to proceed forward with Dr. Zeman, which left the defense with no options other than to file the motion to order Mr. Stevens to comply.
Good. Mr. Stevens, I was just concerned about that month delay, and I was like, wait a minute, what happened? And there wasn't a month delay, so I'm glad. Mr. Stevens, I'll see you no later than May 16th, okay? When the doctor comes to talk to you, talk to him. It's, you know, I mean, they're there to help the court evaluate. I'm in a deadlock until I hear from an expert, okay?
And Mr. Stevens, in candor to the court, was explaining to me his medication schedule and has asked for the evaluation to take place in the afternoon because he takes medications in the morning. I informed my client that I would certainly reach out to Dr. Zeman, let him know that, so that they can schedule the evaluation in the afternoon.
Okay, good. Thank you, sir.
Okay. So you'll come back to court on the 16th.
Thank you. Morning, Mr. Jordan.
How you doing, Mr. Brown?
Doing well. How are you?
I'm best could be expected. Huh?
Yes, sir. Yes, sir, Mr. Cobb.
Yeah, Judge, this is State Timothy Jordan, 2023-1982. We had filed a motion to dismiss. It's a C4 motion. I have incorporated one of his motions, and it's all, I think, done procedurally correct. And I've been in discussions with the state about this motion to dismiss. And I believe the state is going to inquire, and if the motion is right, they're going to dismiss the charges. But I can let Mr. Gomez explain why he thinks he wants a little bit more time to chase down some facts to make sure before he does that.
Yes, Your Honor, without getting too far into the weeds, this particular charge was included on whenever they served or executed a search warrant, and he was arrested on another charge. In reading the report, I think as it was charged by the state attorney's office, I don't want to say it was charged incorrectly, but I don't see why it was charged on a particular date. I think it should have been charged under another statute. I think candidly, the charge that it's charged under, I think the motion, we wouldn't be able to traverse or do anything like that. However, in reading the facts of the report, I don't believe that it was charged accurately, and I need to really flesh that out because there's a lot, as I'm sure you're aware, there's a lot of these new failure to register charges coming through. This particular subsection of the failure to register statute has specific language that I have questions on, even if we would be able to charge it under that statute. We are currently, Mr. Jordan is being held on multiple cases, and so I don't believe that this continuance would prejudice him in any way. I do want to be able to flesh out this particular subsection, and if it comes to light that I don't feel like we have the necessary facts that support a charge, then I will immediately null pros the case. However, if it is a situation where I need to file an amended information, and a motion would then need to be heard. In speaking with Mr. Cobb, and I think Mr. Clines had kind of alluded to this earlier, that if we could potentially schedule a day before the May pretrial. I mean, we do have a little bit longer in between this being our last court date before May, we actually have, I think, 3 weeks, which normally we only have 2. So if there is a date that this court would be okay with, maybe early May or late April, then we can schedule it for that date as well, and I will have an answer, I'm hoping, within the next 7 to 10 days. But that was why the state was requesting a continuance. And to be candid, Your Honor, I didn't prepare as much as I would have liked, because when I pulled the docket, I always pulled dockets for substantive motions in the PM 14 days before. This was docketed for the morning, and so candidly, I missed it, and that's why I wasn't more prepared and had the amended info filed. And so I just want to be able to flesh that out and accurately resolve this case, whether that be dismissing or amending the info and filing a traverse.
Yes, sir, and I spoke to Mr. Jordan this morning. I explained to him the situation. I explained to him my conversations with the state. The reason I don't have an objection, and I don't believe Mr. Jordan has an objection to a wee little continuance, is because I'm confident that when the state flushes the facts out, they're going to see that this charge, either way, the other section or this section, isn't valid, and I'm hoping it will be dismissed. So,
And Mr. Jordan's being held for other cases, not just this.
yes, sir, that's correct.
Okay. I mean, that's the thing that my ears go up on, because I'm like, wait a minute, why are we delaying? If Mr. Jordan's being held on other cases, it wouldn't get him out based just solely on this case anyway.
Right, and my whole thought process is with that, and I've explained to Mr. Jordan, is if I do get the failure to register charges dismissed, then I would immediately file for some type of motion to reduce bond, but I need to do them separately in order, because, you know, the failure to register charge is it's a big stinker of a charge to hang around for defendants asking for bond reductions.
I understand.
So I've explained that to Mr. Jordan. I think he's on board with it, correct?
Okay. When you ask, the only date we've got is May 13th, the pretrial date. Is there any reason to bring this case back on that date versus 3 days later on May 16th?
Well, no, I was saying we could schedule it for May 16th, but I think the idea is that if we come to the conclusion that we do need to get in front of you sooner, I think there's been discussions in previous cycles where if you potentially have an open day and we're here and maybe Mr. Kleins and I could take a couple pleas, or somebody else could take pleas, and we can get some people off. There's been talks before that we may be able to add a date. That was the only thing that I was talking about in terms of if we could, and it works out that way, we could potentially get them in earlier. But if not, the state would be okay with the 5/16 date if Mr.
Okay,
Cobb is.
Let's stop and just be express about it. You're right, we've got Thursday at 12:30, every Thursday at 12:30. A week from today, I'll be here. 2 weeks from today, I won't. It'll be another judge covering. So if there's ever anything that's gonna enter a plea that's gonna get somebody out of jail,
We do it
at
Thursday?
12:30
Oh.
on Thursday is great with me. I think back and smile, thinking about a Pensacola judge that says, I'll take a plea anytime, anytime, no matter what that is. We don't have the ability to do that because we have to have a clerk, court reporters, all that stuff. But at 12:30, the stage is set for that. So yes, sir, if there's ever anything, you don't need my consent. I also smile, I think about Judge Remington when I was telling him something about something I was doing on a case that, on one of his cases, when I was a judge. And he said, wait a minute. He said, if you're getting a case off my docket, you don't have to ask me for it. So if you're going to help a defendant out to get out of jail and it's stipulated to, then you don't have to ask me for permission.
Yes, sir.
Thank you, Your Honor.
Good. So I'll see you no later than May 16th. Okay? Thank you. Thank you, sir. Hey.
This is Mr. Scott's Monday.
Yeah, I got already. Yeah, I know.
Removed from the pretrial conference document? Or you want it? It's already set for that.
No, then we want to leave it. It was a new case.
I would say you leave it on for pretrial as well, Your Honor.
Yeah, but just special set that.
Yeah, because we wouldn't be able to, if we have to make an argument, we wouldn't be able to have those arguments on 5/13, so I think it still needs to be 5/16 just in case.
So we're going to set it with subpoenas on the 16th?
Yes, this is a motion to dismiss, so I don't know necessarily if subpoenas would be necessary, but yes, it would be a substantive hearing on 5/16.
Okay, so let's leave it on the pretrial and then set it for May 16th at 2:30 for the motion to suppress.
Okay.
Motion to dismiss, I'm sorry. Good morning, ma'am.
Yepez or Yepez?
Sometimes it means E, or sometimes it makes like yes.
Yes.
Judge, this is State versus Mrs. Yepez.
Yes, sir.
I just asked her why the Y wasn't silent in this case, and she explained it to me. For it says Yepez. I've been calling her Yepez, and I apologize for that. We were here on Monday, and I had filed a motion for her immediate release because the state had not filed an information. Of course, as soon as I filed that, they filed the information, which pretty much made my motion pointless. But on Monday, I also raised the issue of possible bond reduction. She has a $33,000 bond, and the court graciously allowed me to place it on this docket so we could address the possibility of reducing her bond. I've spoken to Miss Yepez, and the $33,000 bond doesn't sound like a lot to some people, but to other people is no bond, basically. She does not have the financial ability to even make the 10% of that. So I've asked the court to possibly consider some type of non-monetary bond conditions that would ensure her appearance on these charges. And we had talked to Mr. Snell about that, and he had agreed to put it back on today's docket, but I believe Mr. Gomez is covering that for me.
Mr. Gomez.
Yes, Your Honor, I think, are you asking for basically argument as to whether, okay, on the bond, I think at this time, we would respectfully request that the bonds remain in place. Given these charges, they are primarily the trafficking in amphetamine. The defendant, while she doesn't have an extensive criminal history by any means. There's only one dealing with stolen property in 2019. There's a possession of controlled substance in 2021. But the concern that we saw was, namely, there was 2 failures to appear. One of them was dismissed. One of them in 2022 was not. She was adjudicated guilty on that. And given the severity of this charges, we do believe there is a flight risk present there. However, given that, the state would be amenable, if this court is trying to financially help Mrs. Yepez, the state would be amenable to reducing the counts 2, 3, and 4 to signature bonds. However, the state does request, given the trafficking charge and the failure to appear as recently as 2022, that the $25,000 cash professional bond remain in place. We do feel that, though, that is a reasonable bond for the charges, and then we would agree to reduce the others to signature, which would take, I think, $8,000 off the bond, which would hopefully make it more reasonable, but that's the state's position.
Okay, thank you.
And I understand the state's argument. I understand the state's position that a $25,000 bond and a tracking charge does seem reasonable. It's probably pretty much in accordance with what we normally do. Maybe sometimes it's even higher, really. But Ms. Yepez's circumstances are such that a $25,000 bond is in fact a no bond for her.
How long has Miss Yepez lived in the area? Do you want to take some testimony on that?
7 years.
Okay. If you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. You can put your hand down. How long have you lived here?
April 1st, it turned 7 years that I've been living here.
7 years. Do you have any family that's here?
I have a sister and I have a cousin and I have my son.
Your son lives here?
Yeah, he's with my sister right now, currently since being arrested.
Okay. How long has your sister lived here?
I think she's lived here a few years. My cousin's lived here since he was like 8 years old.
Well, how long is that? I don't know how old your cousin is.
Oh, he's like 30-something.
Okay.
Okay. If you'll just give me a moment, Miss Yepez. I saw that it was a motion hearing, but I didn't see what was set, so I didn't do my homework. you'll give me a moment. It always stops me for a second to look at the first appearance information when it says failure to appear, and it looks like it says 11, but they are doing hash marks, and it's 2. I'm just reading the sworn statement in the arrest report. Miss Yepez, where did you reside before 7 years? Where'd you live?
I lived in Las Vegas.
Okay. Do you have any family there or anybody
No.
there? How long were you in Vegas?
I was there for like 2 years maybe.
Okay.
And then I lived in California the rest of my life.
Okay. Do you have any job here for the last 7 years? What have you done?
Yes. I've worked at numerous restaurants, but right now, currently, I was working at Rotten Apple. It's a bar in Destin.
Okay. Mr. Cobb, you mentioned a more intensive, basically pretrial conditions. I mean, when you said that, I wrote GPS. As far as pretrial services, what about a different level of pretrial where she would check in and not do the GPS because that would be more money?
I think that would be very acceptable.
Your Honor, I'm sorry, I was talking with pretrial, but I do know that there is a general consensus that they don't want to use GPS for non-sex crimes. So if you're inclined to give a bond, I don't want her to be on GPS because then that causes problems for pretrial.
Okay, thank you. So as far as the level of pretrial services, and there wasn't any allegation, I mean, there was the trafficking, possession. Miss Yepez, I'm just thinking out loud. You know, I don't know how much, you're in any indication that it's alleged that you were using at the time. So I don't think substance abuse, you know, evaluation or any of those things is required, or random urinalysis. Ms. Yepez, you don't think that you can come up with $2,500?
I can. I've been incarcerated for 2 months now, and I haven't been making any money to like be able to pay that. So I mean,
Yes,
I
ma'am.
just can't.
And that gets the court's attention. If you've been in jail for 2 months, certainly shows that you can't post that. I'm going to grant your motion in the sense that counts 2 through 4 will be converted to signature bonds. Count 1 will be a $10,000 cash or professional bond and a $15,000 signature bond. So you'll need to come up with $1,000 to the bail bondsman. I do appoint pretrial services, and you'll have to check in with them weekly.
Okay.
Will I see Miss Yepez on May 13th?
Yes, sir, you will.
I'll see you then at 9 o'clock, okay?
Okay, thank you. So you want 2 different bonds for 1 count?
Yes, ma'am.
Thank you, Judge. Those are my cases.
Thank you, Mr. Cobb.
Thank you.
Have a great day.
You too.
Thank you. Mr. Noakes?
Judges, Mr. Parker Stewart, we've got an agreement worked out.
Okay.
I think he's got somebody else on deck, dude.
Okay.
Hello again, Mr. Stewart.
She's standing right there. May I approach her?
Yes, sir. Mr. Stewart, if you'll raise your right hand. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Stewart, did you read the plea agreement?
Yes, sir.
Did you sign it?
Yes, sir.
Do you understand what, do you understand what community control entails?
Yes, sir.
Do you have any questions for the court or Mr. Noakes or the state?
No, sir.
Mr. Stewart, I do accept your plea. You're adjudicated guilty. You'll need to pay the $100 VOP fee, the $150 public defender's fee, or public assistance fee, I'm sorry. The balance of your probation is converted to community control. And then in 24 MM 1266, you're adjudicated guilty. You'll need to pay the court cost, $100 legal assistance fee. So is he just...
Judge, I don't believe he would be
time,
on
sir?
probation or supervision for that one, but it's just a court cost and adjudicate.
Okay. So time served on that?
That's fine.
Okay. The original terms and conditions of your felony case are reimposed, other than you're on community control.
Yes, sir.
Okay. Thank you, sir. Good luck to you.
Judge, I think I'm supposed to say on the record that we'll stipulate to the court accepting jurisdiction to deal with a misdemeanor case.
Okay. Yes, sir. Thank you.
Thank you, Judge.
Thank you. Have a good day.
Good luck to you,
Thank you,
man.
sir. You too.
Carmen Campos is next with Mr. White.
Good morning.
Good morning, sir.
Good morning, sir.
On behalf of Miss Campos and 23 CF19.
And Ms. Campos, I did read the motion to set bond, so I've done my homework.
Thank you, sir.
Mr. Switek?
Your Honor, if I may approach.
Yes, sir. It's good to see you face to face, Mr. Switek, instead of in wherever you were, with a grandchild, maybe. Thank you.
I was actually in New York
This last time.
Okay. Yes, sir.
Your Honor, we're seeking a bond, a reasonable bond for Miss Campos today. She is on supervision out of Oklahoma. I believe that, is that Cherokee County?
Yes, sir.
In Tahlequah. And those cases out there allegedly led to the violation over here. She does have a stable place to live out there. She's 100% disabled from the Veterans Administration. She takes care of her father, who's blind.
He's also a veteran.
And he's also a veteran. it's very important for Miss Campos to get out now. And the reason being, I know we don't normally do it, but she is 100% disabled, as I showed you in the letter. When she gets to 60 days of incarceration, she loses her VA benefits. So we're asking that the court give her a reasonable bond in this matter.
To the state?
Your Honor, this time the state's just respectfully requesting that the bond or a request for bond be denied. Simply put, the defendant was out on probation when she committed a new law violation, and she actually ended up pleading to that new law violation already. I understand the concern that VA benefits come into play. However, VA benefits should not be the basis for somebody not being held to the same standards that everybody else is held to. If somebody was in front of this court without VA benefits asking for a bond, they would be held to the same standard that they committed a new law violation while out on bond. And so for those reasons, we feel as though she should have taken that into account before committing the new law violation. She should have taken that into account before she made the decisions that she made that put her in incarceration. And so for those reasons, we respectfully request that the bond remain at 0 for this case, as she committed a new law violation while out on probation, Your Honor.
Thank you. Mr. Switek, anything else?
Yes, Your Honor. I point out that her cases out in Oklahoma and the status of that is inadmissible without certified records because they're hearsay. Moreover, the fact that there may have been a plea entered is not reason for a revocation. And I've got case law to back that up if the court wants to take a look at it. Ms. Campos presents with various mental health issues. So at that time, those issues, there was a direct nexus to the events that she was arrested.
Objection, Your Honor. If we're going to play hardball and he's going to object to mine, I'm going to be forced to do that. I object to everything that he stated about her medical condition, as there has been absolutely no evidence presented about any sort of diagnosable medical condition.
Well, if the state had reviewed the Oklahoma records in the cases out there.
Objection, Your Honor. He literally just objected to me mentioning the Oklahoma cases and yet turns around and does it again. I wasn't going to take this position. I'm only taking this because he took it, but you can't have your cake and eat it too. That's just not how this works.
Well, if we can't consider the Oklahoma cases, then there's no reason to be here because the sole reason for the violation are the Oklahoma cases.
Ms. Campos, the reason why I'm smiling is, you know, the courts in Northwest Florida, I don't know if they do it in other states, but at least the majority of the courts that I'm aware of don't require all, you know, testimony of everybody. The attorneys have kind of tacitly agreed to let each other talk about what the alleged facts are and those things, and then the court bases the motion to reduce bond based on that. I think technically, again, if both of the attorneys are going to play hardball, we'd have to have an evidentiary hearing where nothing's in evidence until it properly comes into evidence as if it would on a trial. And so I'm in a kind of a unique situation at this point. When I was doing my homework, I just looked at the sworn statement in the arrest report. The original on July 30th of 21, as far as the allegation of smashing the front and rear windows with a cinder block, and it says while intoxicated. I do see, and this is the case I was thinking of when another case was here, where it says pretrial supervision was mental health pretrial, which gives some credence to what Mr. Switek was stating. Also requires you to take medications as prescribed. and that was 8/2 of 21. Then I look at the warrant that I signed, and I look at the dates in there. You know, there are a lot of different things, but I look at the dates. If everything's on one date, it's a different weight to that than if it's on separate dates. And the violation for the protective order in Oklahoma was December 12th of 22. And then on January 16th of 23, so about a month later, the reckless driving, also the resisting arrest, the restraining order, disturbing the peace was in February 1st of 23. So I've got December 12th, January 16th, January 31st for the restraining order, and February 1st for disturbing the peace, public indecency, injury to property. So I've got more than one date. I do understand the huge downside to you of keeping you in jail, but I do have concerns about the safety of the community, so respectfully, your motion to set bond is denied. So when will I see Miss Campos next?
It's a VOP judge, so.
Okay.
Do you want to go ahead with the evidence?
And we'll file this as Defendant's Exhibit A, and that's admitted.
Okay.
Is there an offer to Miss Campos from the state?
Not at this time, Your Honor.
I don't think so, Judge.
Hold on there, Your Honor, I can make one. Let me just look at something real quick and I'll make an offer.
The cleanest way to do this is to reinstate her. She's already on supervision of Oklahoma. Oklahoma was supervising her on this matter over here.
She's past term, Your Honor.
Okay.
She was arrested a month ago.
Okay. Why don't we do this, since we've been working almost an hour and a half? Let's take a 10-minute recess, and then we'll come back.
Judge, I just want to, we're just going to try, this is mainly to help probation. We're just going to do adjudication to give credit for time served when she's done with probation here. That's the offer.
We accept.
Ms. Campos, have you ever been adjudicated guilty of a felony before?
I don't know what that is, sir.
Okay. Yeah, let's take a 10-minute recess, and then we'll come back and talk about it, okay?
Yes, sir.
We're in a recess for 10 minutes.
All rise, please.
Oh,